Tonight, we begin with a legislative development that Texas immigrants, advocacy groups, and legal experts had feared, monitored, and prepared for in equal measure. 3 immigration reform bills that unfolded not over months of careful deliberation, but in a single 72-hour legislative session. 72 hours that will reshape the legal landscape for millions of immigrants across Texas. 72 hours that will alter how local law enforcement interacts with immigrant communities. 72 hours that will determine whether families stay together or face unprecedented separation. What the Texas legislature did this week crossed a line that immigration advocates had hoped would hold. And when that line broke, immigrant communities did not hesitate. They responded with organization, mobilization, and determination to understand exactly what these new laws mean for their future. For 18 months now, there had been signals, not official announcements, not formal press releases, just signals, that Texas lawmakers were preparing something significant on immigration enforcement. The Texas legislature has been conservative, yes, but they have been methodical in their conservatism. Their moves have followed a certain rhythm, a predictability, almost a choreography. But what set off alarm bells in immigrant advocacy offices across the state this January was that the rhythm went silent. Immigration attorneys who monitor legislative activity know the indicators. The pre-filing of symbolic bills that never make it to committee. The public hearings where community voices are heard but rarely heeded. The gradual buildup of political momentum over multiple sessions. The sudden disappearance of public debate. All of that went quiet. And whenever the Texas legislature goes quiet on immigration, it means something is about to get loud. For months, community organizations had been tracking whispers from Austin. Legal aid societies had been preparing informational materials. Consulates had been briefing their citizens. But nothing could have fully prepared immigrant families for the speed and scope of what was coming. The silence wasn't absence. It was preparation. Early Tuesday morning, legislative watchdog organizations detected what they described as coordinated bill advancement, including procedural maneuvers that had not been deployed in over a decade. These are the kinds of legislative tactics that lawmakers only employ when they are signaling something very specific. They're bypassing standard committee processes, they're limiting public testimony, or they're fast-tracking measures they know will face significant opposition. Observers didn't know which category this fell into, or whether it fell into all 3 at once. But what they did know was that the legislature was changing strategy. And when state lawmakers shift legislative strategy without extensive public explanation, even by procedural measures, immigration advocates pay attention. The 3 bills, Senate Bill 147, House Bill 892, and Senate Bill 203, emerged from committee with amendments that had never been publicly discussed. Each bill targeted a different aspect of immigrant life in Texas. But together, they formed a comprehensive enforcement framework that legal experts are calling the most aggressive state-level immigration legislation in modern Texas history. Senate Bill 147 focuses on employment verification, requiring all Texas employers with more than 10 employees to use enhanced e-verify systems within 90 days. House Bill 892 expands local law enforcement cooperation with federal immigration authorities, allowing county sheriffs to inquire about immigration status during any lawful stop. Senate Bill 203 restricts access to state-issued identification documents, requiring proof of lawful presence for driver's licenses, state IDs, and even certain professional licenses. Each bill alone would have been significant. Together, they represent a fundamental restructuring of how Texas handles immigration enforcement at the state level. The warning issued by immigrant rights organizations tonight was not normal. It was not routine. It was not symbolic. It was urgent. Legal experts, after emergency briefing sessions, described the legislature's move as sweeping in scope, immediate in implementation, and perhaps most importantly, coordinated in a way that maximizes enforcement while minimizing the ability of families to prepare. But warnings only work if the target hesitates. Texas immigrant communities did not. In fact, their response this week was among the most organized we've seen in recent immigration policy battles. Here's what we know. Within 6 hours of the bills passing their final votes, immigrant advocacy organizations launched comprehensive Know Your Rights campaigns. These weren't the standard pamphlets distributed at community centers. These were multilingual digital toolkits, resources that included video explainers in Spanish, Vietnamese, Mandarin, and Arabic, legal hotline numbers, and step-by-step guides on how to document encounters with law enforcement. Legal aid societies in Houston, Dallas, San Antonio, Austin, and El Paso immediately began scheduling emergency consultation sessions. Immigration attorneys are reporting that their phones have not stopped ringing since Wednesday morning. Consulates representing Mexico, El Salvador, Guatemala, Honduras, and other countries with significant populations in Texas have issued their own advisories to their citizens. The Mexican consulate in Houston alone has scheduled 5 town halls this week to explain the new laws and provide resources. Tonight, legislative analysts confirmed that Senate Bill 147's employment verification requirements will affect approximately 180,000 Texas businesses, including restaurants, construction companies, and agricultural operations that had previously used the voluntary E-Verify system. The bill mandates verification before employment begins. Employers cannot hire first and verify later. They must check documentation within 3 business days of offering employment. They must maintain verification records for 7 years. They must face penalties of up to $25,000 per violation for first offenses, with subsequent violations potentially resulting in business license suspension. In other words, Texas has created a mandatory employment verification system with enforcement mechanisms that exceed federal requirements. The verification infrastructure that would have made it voluntary is now obsolete. This is what made immigrant advocates' warnings so urgent. The legislature's employment verification mandate wasn't just symbolic, it was actionable, with real penalties that would force employer compliance. It represented the kind of legislative framework that could fundamentally alter hiring practices if left unchallenged in court. And advocacy organizations, understanding that fully, responded with legal strategy, not recklessly, not impulsively, but strategically. They didn't file blanket lawsuits challenging the entire legislative package. They didn't organize protests without clear legal objectives. They identified the constitutional vulnerabilities in each bill. They filed targeted preliminary injunction requests in federal court. House Bill 892's law enforcement provisions are equally concerning to civil liberties advocates. The bill allows, but does not require, local law enforcement to inquire about immigration status during traffic stops, wellness checks, and other encounters that don't result in arrest. This discretionary language is what worries constitutional scholars most. It creates the potential for inconsistent enforcement across different counties, different cities, even different police departments within the same jurisdiction. A driver stopped for a broken taillight in Harris County might have a completely different experience than someone stopped for the same violation in Tarrant County. The bill provides no standardized training, no oversight mechanism, and no data collection requirements that would allow communities to monitor how these powers are being used. And here's where the story becomes even more complex. Immigration policy analysts now believe that the legislature's legislative package was designed to test the limits of state enforcement authority after years of federal immigration policy uncertainty. Texas lawmakers wanted to see whether immigrant communities would mobilize effectively or whether fear would lead to silence. But instead, the opposite happened. Advocates didn't retreat into defensive postures. They launched proactive community education campaigns that were so comprehensive, so multilingual, that even state officials took notice. You don't get the Texas legislature's attention on implementation easily. But this week, organized immigrant communities did. policy researchers speaking with immigration law journals under anonymity described the legislative strategy as enforcement maximalism, a way to push state authority to its constitutional limits. But immigrant communities proved this week that they remain both informed and organized. Their response was not only swift, it was coordinated so precisely that within 48 hours of the bill's passing, Know Your Rights materials had been translated into 12 languages and distributed to churches, community centers, schools, and workplaces across Texas. That linguistic accessibility matters because it shows something fundamental about modern immigrant organizing. It shows that communities are not waiting for mainstream institutions to protect them. They are building their own protection networks. Senate Bill 203's identification restrictions create perhaps the most immediate crisis for mixed-status families. The bill requires documentary proof of lawful presence in the United States for anyone applying for or renewing a Texas driver's license or state ID card. For DACA recipients, the bill explicitly states that deferred action does not constitute lawful presence for these purposes. This means that approximately 94,000 DACA recipients currently living in Texas with valid driver's licenses will face documentation barriers when their licenses come up for renewal. For individuals with temporary protected status, the bill creates ambiguity. TPS is technically lawful presence, but the bill's language suggests that Texas may require additional federal documentation beyond what TPS recipients currently possess. As reports continued coming in throughout the week, we learned more about the scale of the community response. The Texas Organizing Project carried out rapid response training sessions in 15 cities, educating over 3,000 community members about their rights under the new laws. United We Dream targeted digital outreach that reached an estimated 400,000 Texas residents through social media platforms in the last 72 hours. Faith-based organizations operating across the Rio Grande Valley reportedly established rapid response networks to provide legal referrals and emergency assistance for families facing immediate enforcement actions. This wasn't just community concern. This wasn't just grassroots organizing. This was coordinated statewide mobilization. This was infrastructure building in real time. And infrastructure building is the one thing that sustained immigrant advocacy has struggled to maintain since the end of comprehensive immigration reform efforts at the federal level. For every enforcement expansion that Texas has passed, immigrant communities have countered with something that strengthens their own resilience networks. Remember, Texas lawmakers thought these bills would pass with minimal public attention. They thought the 72-hour legislative window would prevent organized opposition. They thought immigrant communities would need weeks to understand the implications. But this week, the exact opposite is happening. Community organizations mobilized within hours, not weeks. Legal challenges were filed within 36 hours of the governor's expected signature. Know Your Rights information spread through immigrant communities faster than the official legislative summaries reached the general public. This level of organization reflects lessons learned from previous immigration enforcement battles. From SB 4 in 2017 to the various iterations of local enforcement cooperation policies that have been challenged in Texas courts over the past decade. What makes this moment so significant and so precarious is that these bills passed at a time when Governor Abbott is under pressure from multiple directions. Conservative primary challengers want more aggressive immigration enforcement. Business groups want worker availability and economic stability. Border communities want federal resources and infrastructure investment. Immigrant families want safety, legal certainty, and the ability to work and drive without fear. Governor Abbott is balancing these demands while managing relationships with the Biden administration on border security and preparing for potential policy shifts if federal leadership changes. And when governors in that position sign controversial legislation, they're not always doing it from political strength. They're doing it from political calculation. They're doing it to shore up support with base voters, while calculating that business opposition won't materialize or that legal challenges will take years to resolve. The American Civil Liberties Union's statement, now circulated widely through legal networks, was designed to signal that civil rights organizations are not willing to allow state overreach on immigration enforcement to go unchallenged. ACLU officials said plainly that the legislature's bills were inconsistent with constitutional protections against discrimination and federal supremacy in immigration law. That is legal advocacy language for, "We're filing suit, and we believe we have strong constitutional arguments." You don't usually hear that tone from the ACLU unless they believe the legal violations are clear and the stakes are high enough to justify immediate litigation. The Mexican-American Legal Defense and Educational Fund, MALDEF, issued similarly strong language, calling the bills a coordinated attack on immigrant communities that will face significant constitutional scrutiny. Meanwhile, community advocacy coalitions addressed overflow crowds at churches and community centers in emotionally charged, strategically focused gatherings this week. Organizers said, "These bills are designed to make you afraid, but fear is not our future." They said, "We have legal rights, we have community strength, and we have each other." And they said, "Know your rights, document everything, and reach out for legal help before you make any decisions about your work, your family, or your future in Texas." These are not rhetorical flourishes. These are statements from communities that understand just how high the stakes have become, and that understand that accurate legal information is the first line of defense against enforcement overreach. Here's what makes the situation even more concerning. The Texas legislature's bills weren't isolated. Along with these three major pieces of legislation, several counties announced they would implement House Bill 892's law enforcement cooperation provisions immediately, rather than waiting for the bill to take effect in September. The Texas Department of Public Safety indicated it would begin enhanced verification procedures at driver's license offices within 60 days. Multiple cities with sanctuary-style policies saw renewed pressure from state officials to abandon those protections. All of this happened within the same week. When state legislatures move multiple enforcement pieces at once, it means something larger is underway, a comprehensive approach to immigration enforcement that goes beyond any single bill. Legal analysts are now considering several possibilities. One is that Texas is preparing to defend these bills all the way to the Supreme Court, hoping for favorable precedent on state immigration enforcement authority. Another is that lawmakers are attempting to create political pressure on the federal government to increase border enforcement and interior immigration enforcement. A third possibility, the one worrying advocates the most, is that Texas is attempting to create a comprehensive enforcement framework that other states will replicate, creating a patchwork of state-level immigration policies that supersede federal authority. But this week, organized immigrant communities took the fear card off the table. They didn't wait passively for enforcement to begin. They didn't hide or avoid seeking legal guidance. They didn't assume they had no options. They organized, educated themselves and their neighbors, and prepared for legal resistance. What we're watching now is a test of community resilience. Texas lawmakers want to see whether enforcement threats will reduce immigrant visibility and labor participation. Immigrant communities want to show they will not be intimidated into silence or invisibility. Federal courts want to prevent state overreach that conflicts with federal immigration authority. And immigrant families want to prevent their lives from being upended by laws that may not survive constitutional scrutiny. Tonight, we've heard from legal aid organizations who are now scheduling emergency consultations through March. They say demand for legal services has increased 400% since the bills passed. They say mixed-status families are the most vulnerable under these new laws, particularly families where parents lack documentation, but children are U.S. citizens. And they say the legislature's decision to implement these bills on staggered timelines is likely part of a broader enforcement strategy intended to create ongoing uncertainty rather than a single moment of crisis. But immigrant communities are not paralyzed by that uncertainty. In fact, communities are building long-term resilience strategies. Their response this week, organized, multilingual, and legally informed, sent a message to Texas lawmakers that enforcement expansion will face organized resistance. And it sent a message to other states considering similar legislation that immigrant communities are prepared, connected, and will fight for their rights through every available legal channel. As the coming weeks unfold, we expect more details to emerge about how exactly these bills will be implemented and enforced. But what we do know is that the community response was immediate and strategic. It provided critical legal information to families who needed it most. It created support networks that will outlast this particular legislative crisis. And it demonstrated that immigrant communities in Texas are organized, informed, and ready to defend their rights. What happens next will depend on what Texas officials do in the next 90 days as implementation begins. If they enforce these bills aggressively without regard for constitutional limits, federal courts have already shown they are prepared to issue injunctions. If they proceed with implementation, immigrant advocacy organizations have already shown they are mobilized, legally prepared, and committed to long-term resistance. They have shown they are ready to respond through litigation, community education, and political organizing. And tonight, for the first time in years, Texas immigrant communities appear to be neither surprised nor unprepared. Community centers across the state are full, not empty. Legal aid hotlines are active, not silent. And when immigrant communities are this organized, it means they are thinking strategically about the long term. It means they are choosing their responses based on legal guidance, community strength, and the knowledge that these fights are rarely won quickly. Because this week, Texas immigrant communities learned something they have learned many times before. Knowledge is protection. Organization is power. And community solidarity is the most effective response to enforcement threats. This story is far from over. But tonight, one thing is clear. Texas immigrant communities are informed about what these bills mean. They are connected to legal resources and each other. And they are prepared to fight for their rights, their families, and their futures in Texas. And we will be here, watching every detail as the implementation phase unfolds and legal challenges make their way through federal courts.